Hello. Welcome to the Chalala Weekly Webinars. Today is July 23rd, 2021, and we've got some really interesting topics we're going to be covering. We're going to be covering H-1B cap updates, July visa bulletin insights, consular appointment updates, and closures, travel bans, national interest exceptions, and emergency appointments. So let us give everyone a few minutes to join. I want to welcome those who are new to our Chalala webinars and in turn say thanks to those who've been coming every week. So let's go ahead and get started without any further ado. Remember, please, if you have a question, we're going to do Q&A at the end. Please put it in the Q&A box and not in the chat. And then we'll have Shaker Chella join us at the end, and he will be moderating the Q&A. So thank you again for joining, and let's get started. So the USCIS provides the 2020 CAP registration updates. The USCIS released the data from the 2020 CAP, stating that it received 613 H-1B registrations for the initial period and selected 87,500 registrations. And so they also provided the comparison. So the H-1B CAP registration process was well received with high satisfaction for the system. 4.7 out of 8. And the registrations were submitted by more than 37,000 prospective petitioners, and roughly 48,000 of the registrations requested consideration under the advanced degree exception. Per the registration, the USCIS uses historical data related to approvals, denials, revocations, and other relevant factors to calculate the number of registrations needed to meet the H-1B cap on a fiscal year. So based on the historical data, the initial projected number of registrations required to meet the numerical limitations was less than the initial number of registrations required for 2021. In 2021, last fiscal year, remember the USCIS fiscal year runs on October to October. So the 2022 fiscal year starts October 1st. So all these H-1Bs are for the 2022 fiscal year. So in last year, the USCIS received 237 H-1B registrations, and initially selected 106,100 registrations projected to reach the allocation. And then in August of 2020, they selected an additional 18,315 registrations due to low volume from the initial number. So it resulted in a total of 124,415 selected registrants. So we'll be continuing to monitor the registration filing dates after the filing period closes, and they may select additional registrations to reach the 2022 numbers. So let's hope that there's more H-1B allotments that we can look forward to. July visa bulletin trends. This month's chats with Charlie Oppenheim from the Department of State were postponed, but you can look at the new visa bulletin and his previous comments to get some insight as to what October might look like. I don't have a crystal ball. These are just assumptions. Last month, Oppenheim predicted the USCIS would accept dates for filing, as the agency has done for previous October visa bulletins. Remember, the numbers open up in October, so that's why they're a little more generous with allowing for dates of filing rather than final action dates for that day. Many stuck in the initial Indian visa backlogs are watching EB2 and EB3 so that they can apply for an EAD along with their I-485 filing. Remember, filing the I-485 under dates of filing doesn't protect a child from aging out unless the visa bulletin advances sufficiently so that the final action dates hit before the child's CSPA date hits 21. Once that happens, even if you filed in dates of filing, once the filing action dates are your priority date and the child's CSPA date is under 21, then it locks it. So here's some trends. Final action dates for EB1 to remain current throughout the year. EB2 India, there was a 6-month jump in July to June 1st, 2011. EB3 was a 15-month jump to July in July to January 1st, 2013. For dates of filing, slow for the beginning of the year, but it now seems to be advancing a little bit. EB2, there was a 4-month jump to December 1st, 2011. EB3, a 1-month jump to February 1st, 2014. So it seems like the USCIS is now getting their stride. With the question regarding should I file a new downgrade I-140 in the EB3 category or wait, if you file now, you may be able to. I always tell people, if you've got the option, why not do it? And you can use the same perm to file a new I-140 in another category. If you filed EB2 before, you can file an EB3. If you filed EB3 before, you can file an EB2. However, if your date is close, you may want to wait until the October, if dates are filing accepted, in order to file the I-140 and I-45 concurrently. That's only if you file, because remember, when you file a new petition, let's say you file for the I-140 in the downgrade and the dates aren't current yet. And remember, when you're filing a new I-140 downgrade, then you don't have the perm with you. So if you file it now, you can in the future change it to premium processing. If you file it now and the numbers are current, you can always file the I-485 and attach it to that I-140 with the receipt notice. Or, you can wait and file the I-485 concurrently. As a timeline reference, for some of the 2020 filings, we've seen some reports of premium rejection, but our office has had tremendous success with the upgrades in the past 2 months. So it depended on where your file is located and what the load is, the workload is from the particular officer that's working on your case. Now let's talk about consular appointments, shall we? Consular appointments 2019 continues to affect consular operations, especially in countries where the variants have taken hold, and we see that country conditions are all different. So there's continued closures, emergency appointments only. Chennai is temporarily closed. New Delhi is taking only emergency appointments. Hyderabad is temporarily closed. Kolkata is temporarily closed. Mumbai is taking only emergency appointments. So you have to check back frequently, different times of the day, to find an open slot. Travel bans, this is separate. These bans are in effect not from the Trump era bans, which were immigration based, but these are based on the COVID pandemic. Now, there is ongoing litigation because the president, although he has the authority to limit entry, he can't limit issues of visas. Applicants should be able to quarantine in a third country in this country is impacted by the travel ban for 2 weeks and then enter. The DOS states that stamping for third country and nationals is not available for routine appointments, but individuals have reported success with emergency appointments. We've got Mexico processing that you can click onto in our previous webinars that can give you some insights and some context to help you with that. Remember, the travel ban doesn't apply to US citizens or permanent residents or immediate relatives of US citizens or permanent residents. There are other exceptions to the national interest given prospective adoptees, air or sea travel by the invitation of the US government and other official government travel. Students and certain academics in exchange visa programs will automatically be considered for a non-immigrant visa. They may enter no more than 30 days before the program's start date. Certain exchange visitors and some au pairs, specialized teachers travel in support of critical foreign policy objectives, and et cetera. Travel for humanitarian aid, public health response, national security, journalists would all come under some of the exceptions. Two most relevant exceptions to many people stuck abroad are, especially, and this is especially true for travel, is travelers who are seeking to provide vital support for critical infrastructure sectors and are directly linked to supply chains. Derivative family members following to join the non-citizens who has been granted the visa would be reasonably expected to get their, derivative non-immigrant visa. So, there are, we've got memos, so, we'll attach a memo that talks about some of this. So I think down below, so please take a look at the memo to get more insights. Emergency and expedited appointments. You must have already confirmed an interview date in order to request an expedite. So that is confirming the interview date. And so you don't make your expedite request prior to that. And there are instructions on our website, link below, that tell you how to exactly do that. You must pay the visa fee, schedule an appointment before requesting an earlier appointment. You can only request an expedited appointment, so you need to have evidence that you can submit together with your application, whether it's a medical need, funeral need, urgent or business travel, and students and exchange visitors. Now, note from the DOS embassy, this is straight off the press, we just got the tweet, that they are unable to approve expedite requests for fall 2021 students with scheduled appointments in July and August. If your appointment date may result in a potential late start date, reach out to your school to discuss options. So 6 hours ago from New Delhi, they said we will open additional appointments soon, yay, in July. Continue to monitor availability and stay in contact with university regarding flexibility of dates. Some people have reported success for medical reasons, family separation, anxiety, medical conditions, etc. Business travel may be possible with employers' assistance, describing the work. And remember, it's not the urgent need for your employer. It is how that fits into within the national interest exceptions for the United States. It's for the greater good, the national good. So make sure when you're writing those letters that is highlighted and very clear. If your emergency, after your request for your emergency request is approved, then you will be notified with the instructions via email. That your request for, if you have not received an approval or denial, that just means it's still under consideration. So applicants requesting an expedited appointment must also submit evidence that they're not subject to the presidential travel ban, otherwise qualify for the national interest exception for the travel ban. Now, the update on the drop boxes. Interview waiver policy has expanded to 48 months. So if you've received, what does that mean? If you've received a visa in that same country within the past 48 months and it's expired, then you may be eligible for Dropbox. Typically, you can be renewed at the Dropbox for an interview waiver. Before it was just 1 year out of the past year, but now they've expanded it to 48 months. The ages available for the Dropbox are 14 to 79. The prior visa was issued after the 14th birthday. The prior visa was lost, stolen, or canceled. No visa refusals since the most recent visa issuance. No arrests, convictions of any crime. Have not stayed longer on a B1 or B2, longer than 6 months on a B1, B2. F1 students that are continuing at their same school are eligible for Dropbox. And blanket applications do not qualify, but L2 visas are eligible. So if you're a non-blanket L, then effectively you would be eligible for the drop box if you meet all the other criteria. So those are updates for this week. Tomorrow we're going to have our Facebook Live. So if you haven't done so, please, if you like our Facebook and you share that on your page, your Facebook page, we'll make sure you get priority in questioning. If you want to remain, if you want to, maintain some anonymity, you don't want to give out your name during the Facebook Live, what you can do is submit your question to info@chalalaw.com and say you will be on the Facebook Live program. Put Facebook Live in the RE and ask your question. And you still have to share our Facebook event on your page, on your Facebook page. And if you do that, like I said, I will be able to, at the beginning, say, here are some questions that we've received for Facebook Live, and I won't have to disclose your name. So you can do that in anonymity. But sometimes it's great for people to disclose what their questions are if they're not too personal and they're more general in nature, because a lot of other people will have those same questions. And, when someone is struggling through the immigration process, it makes them feel good that, they're not the only one, that there are other people that are struggling through this process as well. So that's why I always call it our immigration community, whether it's our Facebook Live, whether it's this weekly webinar. I feel like we are here, all of us, for each other. And there are many ways to connect with us. You can connect with us on Facebook, Instagram, Twitter. You can join our Telegram group, and the links are below. And be part of our community in many forms of conversation, so it's not a one-off. And there's a lot of really great information on our previous webinars, detailing a lot of things that we've talked about today. So I hope you subscribe to our YouTube channel and share it with your friends. Help us, get the word out. There's a lot of people that put time into putting this project together. I am just the face of Chella Law, but Chella Law is, like they say, it takes a village. And I've got a phenomenal team that helps us put this together every week. So for their hard work, and as my request, please help us spread the word as much as you possibly can. So now let's get to, our Q&A, and I will invite Shekhar Challa to join us so he can moderate the questions and we can get all your questions answered. And whatever we can't answer, we've got about a half an hour, more than a half an hour of time. But whatever we can't answer, remember, you can send us an email. So Shekhar, we have a hard stop at 1. And I'm telling them that whatever questions they can't answer, they can join us on our Facebook Live tomorrow evening. I believe it's from 7 to 8. And if you want me to answer a question on Facebook Live anonymously, you can email those questions to us. And in the RE, the subject line, you can put Facebook Live. You will still have to share our Facebook Live event page on your Facebook to get priority in terms of during the Q&A. But I would really appreciate you doing this, and I want to thank you in advance. So Shekhar.
All right. Good afternoon, everybody. Hello, Lakshmi. How are you? I see, as usual, I would request put your questions in the Q&A box and leave the chat for any clarification. I see a couple of, questions. What's the new update on EAD policy? Does it affect current EAD policy? So that's a question in the chat, general question.
Right, and I think we had, Kara, I think we had either a memo or I think we discussed this in our previous YouTube webinar in great detail, outlining the exceptions of when a biometrics is needed. And so if you check out our chat, they'll put it in there, but it's good news. There are tremendous, the USCIS is really trying to look at how to process the EADs in a efficient and expedited manner. So check out.
All right. So first question from an anonymous attendee. My spouse current H-4 EAD is expiring on June 29th, renewed on May 15th. Also applied I-485 on November 2020 and PD current in July Bulletin. What are the chances to get GC, GC EAD, H-4 EAD after June 29th? She has to be out of job. Please suggest if I have any options to expedite.
Well, if you're out, did you say she's out of a job?
Yeah, I mean, she says she has to be out of jobs. I'm not sure what that means. I guess
Well,
it's expiring on 29th, so she'll be out of job probably.
yeah, so if you have not filed an I-140 or 485, you can always change employers and go through the process anew. I don't know how supportive this employer is to continue your I-140 and 485 if you're out of a job, because I don't know whether that means your H-1 is going to expire, you're going to hit the 6 years, or what it is you're exactly saying. So if your H-1 is getting ready to expire, you can always file if your I-140 has already been filed, because that's how you'd have a priority date, then you can continue to extend your H-1B. If your job is at question, there was a webinar that we did that talked about, here are some things you can do if you are concerned about your job. And they'll post that webinar on our chat. So you can take a look at that, and it goes into it in much greater detail. It's just focused on that.
All right. Next one is a question from YouTube, Mandeep Raj. Do you expect similar PD movements in both EB2 and EB3 in August Bulletin as well?
Right, similar to what they were. Yes, I do. And so we can start seeing that same kind of movement going forward.
All right, next one is from an AA. I-485 status showing issued RFE and waiting for copy. Applied multiple I-485 on EB2 and EB3, and currently both are in final action date. Can we assume, it says RFIE, probably, I don't know if there's something different than RFE, is related to withdraw one of I-485.
Right, that's probably what it is. It's either that or medical. So I would expect that the USCIS is saying, hey, buddy, you've got to. And so the misconception is that you can't file two. You can actually file two 485s, two adjustment of status applications. What the regulations say is you can only adjust on one. So then the USCIS will come to you and say, which one do you want to keep and which one do you want to withdraw?
All right. Like I said, please put your question in the Q&A. I got a question in the chat. I'll take it in the order it was received. Next one is from Chintan Shah. Currently, I'm in UK on work visa, and I have received approved H-1B visa. My kids were born in USA. I'm not getting immediate date for visa stamping in London. I want to raise an expedite request for visa interview. What should be the best way to get expedite appointment? Right.
So we had a webinar that talked about, how you can secure appointments. If this is your first H-1B, so you didn't have a previous H-1B, your main bet would be the national interest exception. And remember, we've done this successfully. The national interest exception, or whether you fall under any of the other urgent needs like family, medical, things like that. So the health, family, medical has to be about you, and there has to be a relationship with why you have to leave the UK and come to the US for any of those personal reasons that you're requesting the expedite. If it has to do with the national interest exception, remember your employer has to write that letter, and the national interest, there are various categories. It cannot be about the harm that it's causing the employer, but the harm that it is causing, supply chain or infrastructure or in some aspect. And there's others that are listed in the national interest exception. And so take a look at our webinar where we talked about this in great detail, but that's how I would approach it.
Okay. Next one is from Ashu. Can I file I-140 now? How many months it takes? I guess that's all was the question.
Okay, so Ashu, is it Ashu, did you say?
Yeah, Ashu.
Ashu, did you, thanks for joining us. Is this a downgrade or is this a new I-140?
Ashu, you can put the answer in the chat, so it's easy to see.
Right. And just to let you know, if it's a new I-140, you can always file it premium processing. If it's a downgrade, you can file it. And then, like I said, I think we started requesting premium processing for our I-140s that didn't have a perm sometime in April, October, November, December, January, February, March, April, 6 months. Some people have reported that they weren't successful in upgrading. We were, we didn't have any problems, but it takes about 6 months when you'd be able to upgrade it to premium processing.
Okay. Another question from YouTube, same person, Mandeep Raj. With perm approval underway with PD June 2014, can I file EB3 I-140 first and later upgrade to EB2 I-140 in case EB2 advances more than EB3?
If you haven't filed an I-140 yet, why don't you file both EB3 and EB2? You can file both EB2 and EB3 at the same time with the same perm. You can even file that premium processing. So that way you can get the benefit of both.
All right. Next one from another AA. My wife is in India, scheduled to travel to US in July 2021, along with the US-born kids, and our current visa valid till August 2021. I have my H-1B recently approved and got my I-797 valid till April 2024. Do I need to send my approved I-797 to my wife in India so she can carry with her and show at port of entry to get her I-94 extended till April 2024? Thank you.
Yes, so she would just, sometimes they may not do that. It depends on how, sometimes it depends on how the passport expiration or whatever, but nevertheless, she would need a copy of your H-1B approval notice so that she is permitted entry into the US.
All right. Next one is from Gopal Arthanari. Hi, Chella team. Once immigration medical papers are signed by physician, is there a 60-day limit within which it has to be submitted to USCIS?
That is correct.
EOS on October 2020 without medicals. My plan is to hold on to the medical paper and to submit it only after I receive medical RFP. Mine is October 2011 PD on EB3 downgrade, I-140 not approved yet.
Well, Gopal, thank you for joining. You don't have to wait. Yes. So to answer your first question, yes, the medical is only valid for that 60-day window. So you don't have to wait for an RFE to submit it. You can always last week, if you check out our webinar last week, I actually talk about how the letter should be, how you can go about doing it. It's pretty straightforward. You don't have to wait for an RFE.
Okay. Next one is from Nivar. You may have answered in earlier segments. Could you explain the reason, if possible, the delay in issuing EAD? I did my biometrics March 2021, but I haven't heard about EAD.
Right.
Praveen.
They are trying to process the EADs as quickly as possible. Like I said, at the beginning of the year, we had two things going on. One was the pandemic. Remember in January, when the Biden administration came into place, we were still, in the process of getting the vaccines out. So the pandemic was a factor. The previous administration did a horrible job in staffing the USCIS. It kept it very skeletal. So there was a backlog as a result of that. So now they're trying to work through that backlog. And we're even seeing it with the adjustment applications, where you can see that initially they started out processing them slow, but now they jumped about 4 months in processing. So I would think that, have some patience. It depends on the adjudicator. It depends on the office that it's gone to, but they are striving to work on those as quickly as possible.
All right, next one is from an AA. Why AILA is not doing anything to force USCIS to use all spillovers?
No, I mean, everybody is, there is a whole slew of lobbying and activity that folks are doing to try to get this processed as quickly as possible. It has even been proposed that, if it's a staffing shortage, add a premium fee to that, add a premium fee to adjustments so that that can pay for the staffing, and then we can move forward and move quickly.
All right, next one is from series. What is the priority date for EB2 category?
Kara will put that up. We talked about that earlier today, the July visa bulletin dates. I think we spoke about earlier in the program. So if you did not catch that, Kara, if you could post it. I think I have it up here. Yes, that in the final action dates is July 1st, 2011 for EB2 India, and it is for EB3 India, it's January 1st, 2013. Dates of filing, it was a 4-month jump to December 1st, 2011, and in EB3, a 1-month jump in July to February 1st, 2014.
Okay. Next question from an AA. What are the chances of straight EB3 June 2012 getting greened before September 2021?
Getting what?
He's using all kinds of new terminology. Getting greened.
Getting greened?
Must be getting a green card probably.
Oh, getting greened. I like that. I like that. And he said, what date is it? And
let me see, straight June 2012.
June 2012. Well, we just talked about what they're currently working on. If it's EB3, remember EB3 moved 15 months, but not, I don't know if that would put you in 2012. And then EB2 only moved 6 months. And we're talking about dates for filing. Final action dates were slower. So if they move according to that, that's probably when you're going to get greened, depending on the category.
All right. Just want to remind again, a lot of questions are in in the chat, but I'm taking the questions in Q&A. I will take the question in the chat as per the timestamp, but please do put it in the Q&A box. Next one is from an AA. Hi, this is Sri Lakshmi. Our priority date is EB2, November 2012, with I-140 approved. We have been with the same employer for 10 years. She's got two questions. Question number one, if I just apply new EB3 I-140 today, can I wait for the October bulletin and then apply I-485 and AP while the EB3 I-140 is still in processing?
Yes.
Okay. The second question is, if I concurrent file I-485 AP and EB3 I-140 today, can I apply EB2 I-140 plus AP once the final action date for EB2 are current while the EB3 filing is still in process?
Yeah, you don't have to refile the 485. If you've got an EB3 and EB2, you can file your EB3 concurrently with the I-485. And if your EB2, especially if they're with the same employer, becomes current, then you can interfile your EB2. So you don't have to file the 485. You just simply file with the USCIS. It's called an interfiling.
Next one is from an AA. Will USCIS be providing any recent metrics on how many EB-based green cards they have been approving from the last October I-485 filings?
I hope so. We were hoping, usually Oppenheim gives us some news on that. We were hoping to get some information, haven't received it yet, but as soon as we do, if you haven't joined our Telegram group, please do, because we'll probably make those available to the group. So you don't have to wait. That's more instantaneous than waiting for the weekly webinar. And I wanted to ask, of the attendees that are here today, I see we've got 51 attendees here today. That's great. How many of you, can you raise your hand if you're new to our Cello Law webinars? Wonderful, welcome. And for all the others that have been, attending, thank you again for your support. And maybe we can ask them a poll, Kara, as to especially, how people found out about these webinars. That may be useful, whether it was the Telegram group or MailChimp, or what ways. So sorry, Shaker, you can continue with the questions.
Oh, no problem. Next question is from an AA. Assumption is filing dates will be accepted in October, I get assuming, given the pace of movement in EB2. If assumption holds true, it may reach 2013. For someone with September 2012, does it make sense to downgrade or just hope assumption turns out true?
Remember, there's no harm in downgrading. There's no, so whatever comes up, you can leverage either movement. That's the benefit of it. So if your company's willing to do that and you can do that, I think it's something you should really consider.
Next question is from SA with the initials. Greetings. My priority date is November 2014 under EB2. My employer is not willing to downgrade. Should I wait for EB2 date, or do you have any other suggestion?
Why isn't your employer willing to downgrade? Is it because I know that initially in October, I talked to a lot of employers that were misinformed, were worried, had a number of other concerns, because otherwise most employers are willing to support it. So if you could, email us and tell me a little bit about why your employer is not willing, maybe we can give you some information that would help him, make the decision. And I see that Kara put the poll up. Thank you so much. And if you're putting other, if you can just let us know what that other is, because that would help us to know, because there's a lot of people that are in other. So if you could just in chat let us know what your other is, that would be tremendous. We've got 41% of the vote. I'd love to see 100% of the people voting. It would really help me get some insight if you could just for a second, take the poll. I really appreciate it. So it is in progress. Go ahead, Shaker.
All right. Next one is from Sai Sagar Adimulam. I got my H-1B transfer approved 5 weeks back, and I noticed my first name was a typo. I also applied H-4 and H-4 EAD a week back using this H-1B form. What are the consequences will be, and will this be an easy fix?
Well, your attorney should now proactively try to get that corrected. So they can, submit information to the USCIS. I would also submit the new form, even though the previous, just to have a signature with the correct name. But they should inform them ASAP.
Okay. Next one is from Aniket Sinker. My final action date is current. Medical RFE was submitted and biometrics done. EAD approved and received. Any guess on ETA for receiving final green card?
I think that we've seen that they're processing them, around pretty rapidly now. They haven't been. And hey, guys, we're only at 52% with the poll. So if you haven't responded to the poll, I'd really appreciate it. If you would, that would be great. So we can see that it's moving faster now. I would think that if you're current now, you could probably see you can be greened maybe by sometime this summer.
Getting greened, that's a good
Getting
one.
greened. I like that. I like that.
Maybe you should patent. Next one is Sri Kotamasi. H-4 extensions are pending since August 2020 for my dependents. Biometrics are done in September 2020. No further updates since then. Is it with Texas? It is with Texas Service Center. How can I expedite the request with the USCIS? Also, I hope my dependent stay is authorized to stay since I-94 was expired on September 15, 2020. Please clarify.
Right. We have a webinar that gives you tips and information to contact the USCIS. So you can do that. I know there's Emma, but Emma is not the only thing. There are other ways in which you can contact the USCIS. And if you look at our webinar, our YouTube link, then that will help you, guide you through this. So check it out.
Next question is from Sri Kumar. My dates are current since last 4 months. I might get my GC anytime. I'm planning to change job using AC21. The process of interviews are going on for my job. My concern is, what if my GC gets approved before filing the 485J with a new employer? Should I still file 485J even after receiving GC?
No.
When is the right time to file 485J while changing jobs?
Well, if you haven't changed jobs and your green card gets approved, and then let's say you get a great job offer, the idea is you would have had to have the present intent to remain with your employer at the time the adjustment was filed. The whole idea of AC21 being able to port to a new employer is after 180 days after the job has been, after the adjustment has been filed. So in effect, the USCIS is saying, okay, if you had the present intent, then you've got to stay with that employer for at least 6 months after the I-140 is approved and the 485 has been filed. So the mere fact that that's where you're way past the 180 days, that after the green card's approved, you can go to a new employer without any problem.
All right. So as per the timestamp, I'm taking the question from the chat. Bhaskar Mailavarapu. My wife got her citizenship and my minor son is 17.6 years. How can I get his citizenship certificate based on his mother's citizenship.
Right. So he becomes a derivative. You can either do it, you can file for the passport itself directly, or I would always get an N-600 is the form you have to file to get a certificate of citizenship. So you would submit, your wife's citizenship, proof of your wife's citizenship, and then, probably your son's birth certificate. It's pretty straightforward. And that's how you could get the N-600.
Next one was from Sanketa Metpalli. Hi, ma'am. My husband has received an L1A visa and the family has received L2 visa. However, due to the current travel ban, we are unable to travel. Can my husband apply for NIE?
He can. It would have to meet some of the requirements within the national interest exception. So check out, I think we posted a previous link on when we went over national interest exception. So check out our previous YouTube video that talks about it. And because in a Q&A, I can't go through the details that is required to explain it, but we have dedicated webinars where this is the topic that we're focusing on. And that's why I'm directing you to those YouTube videos, because that way you can have all the information, what the letter needs to look like, what the process is. And thank you so much for your question. And if you all find the YouTube videos that we're referencing helpful, please subscribe to our YouTube channel so that you can get alerted whenever we have new updates.
If I recollect, I did see an email from Sanketa and I just replied, in about half an hour back. So you can reply to that and maybe send more information and, send your resume or whatever documents. So, the team will be able to look at that and respond. Next one is from Ramesh Kumar. Hi, I'm Ramesh. My PD is January 22nd, 2014. I already downgraded my application last November 2020 with Challa Law, but got denials twice and now with Ombudsman's Office. What are my chances of getting GC in near future as I see good movement recently? My PD is January 22nd, 2012 in EB2.
Right. And so in October, if you remember, there was this whole back and forth about public charge. The public charge, they had said that it was required first, and then the public charge was connected to the form. What was it, the form? I forgot. Well, whatever the crazy public charge form. So then, because of a lawsuit, the federal court said, hey, public charge is no longer applicable. This is between October and November. Unfortunately, for those that were filed on that day of the decision where they said, okay, we're taking, so the ones that were filed previously were filed with the public charge document. Then when the federal court said you cannot file, USCIS, you cannot accept public charge documents, we could not file with that, so we did not file. Then the appellate court made a decision to lift the, the USCIS was enjoined, so they lifted that, saying, yes, the USCIS can accept public charges. The problem was FedEx leaves at 5, 6 o'clock. The decision came out later in that evening, that night. So those that were filed on that day, that were filed without it, have been systematically rejected. So what we're telling USCIS is, and we're fighting with them, number one, now the public charge is not even an issue. The Biden administration has done away with it. Within that time frame, it is illegal for the USCIS to request or to reject a I-45 due to the public charge documents. It is a mistake. Unfortunately, sometimes when they make a mistake, it takes a little while to correct it. So we're definitely going to escalate it. And if we don't hear back from the ombudsman in a couple of weeks, then we'll elevate it a step higher to the senator's office and so forth, and make sure that we make a lot of noise to get this resolved. But thank you for your patience.
Okay, I'll take two more questions because there's a hard stop at 1 o'clock. So the last question will be from Abir Singhal. So before that, I have another question. So the rest of you, please apologize because of the hard stop today. Please send your questions.
You can join me tomorrow on Facebook Live from 7 to 8. We're doing it in the evening, so it's after work and it's easier for you. And if you share our Facebook on your Facebook, our event information on your Facebook, and you'll get priority in me answering your questions tomorrow in the order that people share over the people that are just asking on Facebook. If you want to keep your question anonymous, you can email it to us, and I will respond tomorrow without disclosing your name in the Facebook Live program. You will still have to share our Facebook announcement on your Facebook page.
And if you can't attend tomorrow, and if your question was not answered today, just send an email to info@chalalaw. We're glad to, send you a response.
Right, but we are getting inundated with a lot of emails at info@chalalaw, so be patient with us. If you need a really quick answer, then join us tomorrow.
Yes. A live service is always preferred. Well, so here's a question from AA. I have H-4 application pending for more than a year. I also applied for adjustment of status in October 2020, and our PD is current in July Bulletin. I just received an RFE for the H-4 that says that I have never sent any documents with my H-4 application, which is not true at all. There is a section in the RFE that references my 485 application. My question is, does the status of my H-4 application affect my GC application at all? Thank you.
No, but some of the questions that they raise without looking at the RFE, I wouldn't be able to tell you. But if they're raising questions about your continued, your maintaining status, then yes, that could. It's interesting that they would have brought up your 485 because they're two independent. I would respond to the RFE. And if you'd like our office to do that, you can email us at info@chalalaw.com and we'd be happy to do that. But I think it's always good to have a safety net, and your H-4 is your safety net.
All right, last question for today. Abir Singhal. Hello, Abir, how are you? Is it possible to claim NIW for an EB1C if the recipient business happens to be involved in a semiconductor critical supply chain? Basically, if I have to leave it, will it affect my customer, who is one of the largest semiconductor test supplier for US and globally? To clarify, claim NIW for EB1C premium processing.
National interest waiver, I don't believe can be premium processed. Only extraordinary ability can be premium processed, and that too, extraordinary ability can be premium processed, but national interest waiver, I don't believe can be premium processed. And Kara will confirm on the chat, because I know that when we're talking to, so national interest waiver is exceptional ability in the national interest, and EB1 can either be multinational manager, which can't be premiumed, extraordinary ability, which can be premiumed, or outstanding researcher or professor. Those are all EB1 categories. EB2 where you file without the perm, where you're filing just an I-140 as an exceptional ability in the national interest with a national interest waiver, I do not believe can be premiumed. They were thinking about that in October of last year, but it has not been implemented.
All right, that's all I have from today for questions. And before I leave, I just want to update all the cricket lovers. It's going to be a pretty sad day today because India will be losing pretty soon. So, but hey, they're in the championship test match. They were hoping to win, but in spite of 2 full days of rain, India could not manage, or rather it's looking like they will be losing unless something miracle happens. But anyway, it was fun. Get up at 5:30 in the morning. Thank you very much.
Yes, he's been putting in a lot of hours, and I even got to watch some with him. So that was interesting. Thank you all for joining. Look forward to having some of you on our Facebook Live talk tomorrow. Please share that with your friends if you can. And I will see you next week. And you all have a safe week. And thank you, Shaker.
Yeah.
And team, especially a big shout out to Kara Wood, who puts in a lot of hard work to make all this seem so seamless. So
I just want to acknowledge, I just want to acknowledge Aniket saying, yeah, at least a good team wins. New Zealand is not a good team. You're right. New Zealand definitely is a great team. I love Kane Williamson because he's the captain of Hyderabad Sunrisers. But, that's all right. We'll win next time.
That's a good game, hopefully. And that's the key, right?
Yeah.
Enjoying the game.
Right. Thank you, Aniket.
Bye.
Take care.
Thanks again.